Hello and good morning or good afternoon to everyone, and thank you all for attending today's webinar. My name is Fred Wagner. I'm a member of the Environmental Practice Group at Venable, and today we'll be addressing the CEQ's proposal to amend the NEPA regulations, what we've called once-in-a-generation opportunity to streamline project development. With me today and helping to present are two of my colleagues, Jay Johnson and Tyler Welty. Jay is a colleague of mine in the Washington, D.C. office of Venable. He focuses his practice on regulatory and litigation issues concerning infrastructure and natural resources development, and he has a great deal of experience in the rail, mining, energy, and biotechnology sectors. Jay is a graduate of UVA Law School. Tyler Welty is in our San Francisco office. Like me, Tyler is an alum of the United States Department of Justice Environment Division, where he represented federal agencies in a wide variety of environmental, land use, and natural resources litigation. And his practice also focuses on project development in a broad range of sectors including renewable energy, water resources, timber, mining, and of course, transportation. Tyler is also a graduate of UVA Law School. And to round out the trio, I am also a graduate of UVA Law School. I'm Fred Wagner, and prior to joining Venable, I was Chief Counsel of the Federal Highway Administration at the U.S. Department of Transportation, and as I said, also got my start litigating NEPA cases in the federal government in the Environment Division. Before we get going, I just wanted to offer a few housekeeping details about the webinar. You should see at the bottom of your screen a couple of applications. I think they call them widgets. These widgets you could resize and move, so feel free to move them around on your screen. You'll be able to slide and maximize the full screen by clicking on the arrows in the top right corner. Most importantly, for purposes of our webinar this afternoon, we are absolutely hoping to make this an interactive session. In an ideal world, we'll leave a solid 15 or 20 minutes at the end of the hour to respond to your questions. And you'll see in one of the widgets on the bottom a Q&A box. And at any time, you can please put in your questions or concerns in that box, and our moderator will be keeping track of them and pass those on to us. And at the end of the session, in the Q&A portion of the webinar, we will try to address as many of those questions as possible. If we run out of time, we'll be able to get back to you after the webinar. So please don't hesitate to put in your questions in that widget chat box. Finally, just to make things a little bit easier for you, these webinars are sometimes a little bit intensive for your computer use. So if there are other applications on your computer in the background, we recommend closing those to allow the webinar to operate a little bit more smoothly. And then everybody who attends this will be able to get a copy of the full slide presentation after the webinar concludes. Later this week, we will send out a full package to everybody that will have all the slides plus contact information if you'd like to follow up with myself, Jay, or Tyler on any of these issues. All right, enough for housekeeping and on to the session. What we're going to do briefly is to provide a little background and context as to where we are and why we are at this point with respect to the potential amendments of the CEQ regulations. Then we will go specifically into several examples of particular regulations that in the past, over the 40-plus years of NEPA's history, have caused a lot of litigation, a lot of concerns, have been the subject to other efforts through legislation that may be subject to consideration and review by the CEQ in the process of amending these regulations. I'll say up front that there's no way that we could address all the issues that could be on the table for CEQ in this webinar, so we've picked out just a few of the highlights, and again, would be happy to discuss in the question period any of the issues that you might want to raise, as well as, again, following up afterwards. So I'm going to start with just a very, very quick background into where we're at. Without going into great detail, we all know that NEPA is regarded in many ways as the grandfather of all environmental laws. and in many ways is unique amongst all environmental laws because it's the shortest. It's very simple. There's not a lot of detail, but yet through that very basic statute, so much litigation has emerged. And we know that the major sources of NEPA law find themselves derived from, of course, the CEQ regulations, individual agency regs, but probably most important at the bottom of this list, judicial precedent. NEPA really is a common law statute where the court's telling you what some of these terms mean. And because the regulations, as we'll get into, in many ways are not very specific, are not very detailed, the courts have really filled in the gaps to let us know what some of these terms mean. And CEQ now is asking the stakeholders, in light of your experience, in light of NEPA practice, and perhaps in light of court decisions, what do you think these terms mean? How should we amend them in some ways to make them more clear, to lead to better processes and better environmental outcomes? This process is not new. Most importantly, as you'll see from this slide, there's been specific legislation trying to address reforms to project review and NEPA streamlining for well over a decade and a half. Most of the legislation goes ties to specific sectors, as you can see, the forest sector, the energy sector, and the transportation sector most recently in MAP 21 and in the FAST Act in 2015. So this is not new. Congress has been thinking about this for a long time. And the community in general has been thinking about this for a long time. I could think back to a session that I attended with then the head of NEPA for CEQ, Horst Gretschmiel, in Colorado, where the very same questions that have been raised in the most current advance notice of proposed rulemaking were raised then for a whole variety of stakeholders about what, if anything, we should do to the NEPA regulations. Interestingly, back then, and that was over 15 years ago, people said, no, don't touch them. Don't touch these regulations. They're elegant, they're simple, they provide a lot of flexibility. Well, things have changed a little bit in that period of time and have led us to this day. But as you can see, it's not just legislation that's been passed. There's current proposals to continue to amend NEPA that relate to, again, different sorts of industries. Broadband, forestry. There's continual drumbeat of proposals through legislation to try to amend the NEPA regulations and the NEPA process. A lot of the energy and NEPA reform has been in the form of executive orders. And the next two slides will show you that both in Democratic and in Republican administrations, there has been an abundance of executive orders trying to get to the bottom of how to provide greater efficiencies, greater accountability, and greater transparencies in the NEPA review process. Here is the list of executive orders from the last administration, and here is the list of executive orders from the current administration. And if you take a look at some of the language on this slide, these are the slides of the post-inauguration of Donald Trump. Read for a moment some of the words and language in the executive order titles. And I'll go back one and look at the words and language in some of these executive orders, and you'll see the great similarities and themes in both administrations, both Democrat and Republican administrations addressing this topic. To reinforce how bipartisan this issue has been, you should remember that in MAP 21, which passed in 2012, the co-sponsors of that bill, which included many NEPA reform provisions, were two senators. One was Barbara Boxer, and one was James Inhofe. So if there's any indication that this has been a bipartisan issue to deal with some of these matters, the co-sponsors should be a pretty good indication that across the political spectrum, this has been a key issue. A couple of the executive orders have been particularly important, we think, in recent years. This one from early on really established the priorities from a policy perspective of the Trump administration. And check out the words here. 3 or 4 times the term high priority appears. High priority projects, high priority to do things more quickly. And this is something that really finds itself at the center of the infrastructure proposals from this administration. Money is not on the table right now, but certainly streamlining the NEPA process is. Most recently, there's been other proposals that introduce some key concepts. Last year in August, a year ago, they talked about this notion of one federal decision, making sure there are coordinated federal processes when there are multiple agencies involved, and that no matter what, anything that would be a, quote, major infrastructure project, we're trying to get through the environmental review and permitting within 2 years. Sure enough, in March of this year, they followed up on that executive order, and the memorandum on one federal decision was signed by, I believe, 12 federal agencies, and it laid out a fairly specific set of criteria and rules that these agencies were supposed to adhere to promote efficient NEPA reviews and permitting. And you'll see that the MOU reflected very specifically, the goals and the policy objectives from the earlier MOUs. This Memorandum of Understanding is quite an important document. We commend it to you to review because unlike a lot of MOUs, it's extremely specific and goes into great detail. Well, the question is all this necessary? Is all this truly necessary? And the question is raised because look at the existing NEPA regulations. There are already regulations suggesting shorter page limitations, already regulations suggesting time limits for the EIS process, and many other techniques to try to make the process efficient and move as quickly as possible. The question then gets raised, well, why hasn't it worked? Despite having the flexibility to do all these things here on the slide, why have we seen the NEPA process extend to many years? Why have we seen extremely long EISs and environmental assessments? Why is that? And I think the result of all that, and not being able to answer that question effectively, why haven't these regulations been used in a way to promote efficiency to date, this is the result. And the CEQ's advance notice of proposed rulemaking happened very recently, as you know. It was a stroke of good timing for our webinar, I suppose. And the deadline for comments on the advance notice right now is July 20th. I know there's been some requests for extensions of that time, but right now it's a very quick deadline. And look at the list of 20 questions that CEQ has asked its stakeholders to consider with respect to what may be at issue and what may be at play for amending the NEPA regulations. It is an extremely broad list. Everything from the basic page and length of the documents all the way to the application of mitigation for major projects. There's really nothing in the scope of the existing CEQ regulations that is not on the table when you read these list of questions. It is extremely broad and all-encompassing for everything that may be done by the CEQ. Again, this is an advance notice of proposed rulemaking. The comments really to help direct the CEQ. This will be, of course, followed by a notice of proposed rulemaking, which will have actual language and suggestions on how to amend and change the existing NEPA regulations, which have not been substantively changed for over 30 years. Well, with that, and that very quick overview about where we've been and why we're at this point, I'll turn it over to Jay, who will dive right into one of the very important CEQ regulations and some of the questions that CEQ may be asking itself with respect to amending the rules. Jay?
Thank you, Fred, and thanks everyone for attending this webinar. As Fred said, we're going to now dive into some of the specific issues in the CEQ regulations that we think are important. Again, there may be many, many more, and I hope that if people have specific questions, they'll go ahead and ask them in the chat room. The first issue I wanted to address is purpose and need. Now, purpose and need isn't something that's particularly emphasized in the advance notice of proposed rulemaking, but we think it's important. I mean, really, purpose and need is one of the first things that we think about when we start a NEPA process with a client. And that's because purpose and need is really the foundation of the alternatives analysis. It's a way for an EIS to be narrowed for alternatives that don't meet the purpose and need to be excluded. Nevertheless, the current rule is just one sentence that basically says agencies will briefly specify the purpose and need to which the agency is responding. That narrowness and that sort of oversimplicity, you might say, has been the source of a lot of confusion in my experience. A lot of times, the fact that the rule is worded to say to which the agency is responding, it almost suggests that this is only for agency projects, and when private applicants come in with a project that needs an EIS, sometimes agencies will try to rewrite the purpose and need, which could expand the number of alternatives or even narrow the number of alternatives, excluding ones that the private applicant actually wants. I've also been involved with EISs where agencies and applicants can't really get on the same page about the purpose and need, and you end up with multiple different purpose and need statements in the same EIS, which is sort of inherently confusing as well. I think the reason for a lot of this confusion is that really purpose and need is different when you have different contexts. Some projects are agency proposals, and the agency really should be controlling the purpose and need, but other projects are private proposals, and in those situations, it's probably more appropriate for the project applicant to be the primary, if not the sole, definer of the purpose and need. So we see here on the next slide that the current rule doesn't really deal with this. The courts have said frequently that agencies can't, quote, redefine an applicant's goals, but again, that's vague and maybe not that helpful in the real world. Courts haven't been clear. Fred mentioned that NEPA is sometimes a common law statute. Well, this is one part of the common law of NEPA that I think is a bit too vague and could use some additional definition from the rules. The slide talks about potential solutions for purpose and need rule. I think that the number one is to clarify how a private applicant's goals should shape the purpose and need. I think in most cases, it really should be pretty straightforward. If an applicant comes to an agency and says, this is the project, and this is why we want to do the project, that should probably be enough for the agency to say, okay, we'll let that shape our alternatives analysis. A clearer rule, I think, should help agencies not only with defining the purpose and need, but also ought to sort of curb the tendency that I see a lot where agencies say, well, we need to have at least 2 or 3 alternatives or it won't be a good NEPA analysis. If an applicant has a project, I think in many cases the need for alternatives that aren't that project probably is a waste of time and money. The next topic that I'm going to address here is one that is really almost every single executive order and statute and every other thing that Fred showed a few minutes ago really goes to the length and the timing of NEPA documents. And Fred briefly touched on this, but the current rules say that an EIS should normally be less than 150 pages and almost never more than 300 pages. And the CEQ 40 questions guidance, which is quite old at this time but still used, says, oh, it should only take about 12 months to complete an entire EIS process. I've been doing this for over 15 years, and I have never seen an EIS be under 300 pages, much less under 150 pages. The most uncontroversial NEPA document I ever helped with, and granted, people don't usually hire us if their projects are completely uncontroversial, but in a project I dealt with where the number of public comments on the draft was probably in the dozens, not the hundreds or thousands that we see a lot of times. The project was on the presidential dashboard of high priority projects. There ultimately was no litigation about the project. It still took over 2 years, and the EIS was 700 and something pages long. So if that's the kind of project that can't be shorter, I think we could we can agree that the 300 pages and 12 months is never complied with. And we have data to show this too. It's on the next slide. You know, the mean and median EIS over a 7-year period was, you know, 3.5 years for the median and over 4.5 years for the mean. In 2012, a similar number came from a GAO report, 4.6 years for the average EIS. That leads to the question, well, should we have time limits on NEPA documents? I think this is a lot of people's instinct, and it probably will be an instinct when people try to amend the regulations. I think the big problem is, how do you impose time limits on a process that is meant to provide a fulsome analysis of environmental effects? What would you do if you hit a time limit and the agency said, well, we're 50% done with our EIS? What's the solution for that? You know, and I don't tend to think that's something that amending the CEQ rules can easily solve. You know, ultimately, in my view, and we're about to talk about a lot of other issues, ultimately, the time that it takes to do a NEPA document and the length of those NEPA documents is really a symptom. It's not something that can be treated just by saying don't make long NEPA documents or don't take a long time. We have to figure out why the documents are taking a long time and what's going wrong that it takes 4.5 years to do an EIS that originally the goal was to have a 12-month process. So with that said, I will hand things over to Tyler, who's going to talk about some more issues.
Thanks, Jay, and thanks everybody for joining us today. Another issue that's been teed up by CEQ is public participation, and this is really a fundamental NEPA issue that relates to one of NEPA's twin aims, to inform decision makers in their making their decisions, of course, but also to inform the public. And so what CEQ has asked is, should the provisions of CEQ's NEPA regulations relating to public involvement be revised to be more inclusive and efficient, and if so, how? This is one of the 20 questions, more than 20 if you include subparts, that CEQ included in its advance notice of proposed rulemaking. And it raises a host of issues and points in the NEPA process where public input may be provided. One that is particularly unclear under the existing law is when EAs and FONSIs, findings of no significant impact, need to be made available for public comment. The existing regulations say that they don't always need to be made available for public comment, only in certain limited circumstances. And what those circumstances are is an issue that's frequently litigated. CEQ's 40 questions document, which is not to be confused with their 20 questions that they recently posed, but is a guidance document released back in 1981. It provides some input, not in the form of a regulation that was put forth in the product of notice and comment rulemaking, but it still leaves a lot of questions open. So one answer to CEQ may involve whether public comment should be required for EAs and FONSIs, and if so, when. A related issue is related to public participation is, how can public participation be encouraged, and how can what I'd call sandbagging agencies be discouraged? And a body of judge-made law called NEPA exhaustion has developed around this issue and might be another subject for CEQ to address in its rulemaking. Because it's a judge-made doctrine, that does raise some interesting questions about how far CEQ can go, but it would seem that CEQ could, for example, specify that an agency doesn't need to consider non-obvious alternatives that weren't raised by the public during the scoping stage of an EIS. CEQ's notice also invites comments on defining and redefining many very important NEPA terms. And one of those terms is the definition of significantly. That term is already addressed in the regulations, and it is defined to require considerations of both context and intensity. Context more or less means the setting of a proposed major federal action, and intensity refers to the severity of impacts of that action and the alternatives. And that intensity factor intensity component is further defined by 10 intensity factors. This is a very frequently litigated issue whenever anybody is presented with an environmental assessment and it's challenged. You'll see an argument that the agency should have prepared an environmental impact statement instead because there is a possibility of significant impacts. And so those intensity factors in particular come into play. One thing that CEQ could do is to define and clarify these intensity factors. For example, highly controversial is one of those 10 factors. And an issue that litigants make is whether controversy means controversial projects or controversial effects. It seems that CEQ intended highly controversial to mean controversial effects, not the existence of controversy around whether a project should move forward. And that's something that would be helpful to clarify. Other examples of intensity factors that might be clarified include endangered and threatened species. There may be ways of syncing the NEPA process and the assessments in an EA with other reviews required by law, including under the Endangered Species Act and perhaps the National Historic Preservation Act. So one thing that CEQ might consider is clarifying that where the service, so the National Marine Service, Fisheries Service, or the Fish and Wildlife Service, who are charged with implementing the Endangered Species Act, determine that an action may affect but is not likely to adversely affect a listed species. Is that enough? That means that there's not significance and that factor does not push a project towards an EIS. A related issue is CEQ could establish thresholds for determining the significance of impacts. So, of course, NEPA requires an evaluation and discussion of environmental effects, but it also, in determining whether an EA or an EIS is required, requires some amount of determining significance. And so perhaps CEQ could, for at least some areas of environmental effects, define significance thresholds. One example recently came up in Sierra Club v. FERC, a recent DC Circuit case where the agency used NACs to define significance thresholds, and the court approved of that. It might be more difficult in other areas. A big question is, what about greenhouse gas emissions? How is significance determined when greenhouse gas emissions are at issue? We might not expect too much about greenhouse gas emissions and climate change out of CEQ at this time, but it's certainly something that we'd expect to see a lot of comments about. I'd just like to remind anybody, if you get any questions, feel free to start asking them now. And we can answer as we go and at the end of our presentation. So significantly is a big topic too, and involves some other questions, including a NEPA document that's not currently defined in the CEQ regulations. It's one of my favorite NEPA terms, a mitigated FONSI. And defining mitigated FONSIs and explaining when a project can be kept as an EA rather than pushed to an EIS through mitigating impacts that would otherwise be significant could provide a real opportunity for good environmental outcomes and streamlining NEPA. There's this phenomenon that I like to call NEPA creep, where agencies and project applicants and sometimes they're risk-adverse attorneys too, push projects towards environmental impact statements to avoid heightened litigation risks that adhere to EAs and FONSIs and, of course, categorical exclusions. But if there is a clearer, more straightforward process that reduced litigation risks and provided for mitigated FONSIs, it could be very helpful in streamlining the process and imposing mitigation that actually reduces environmental impacts. So on this topic, CEQ might address the need for enforceability of mitigation measures or how they might be tracked. The success of those mitigation measures might be measured going forward. CEQ also invited comments on the definition of various NEPA documents. One of those documents that is frequently litigated is supplements. The existing regulations provide that an agency needs to prepare a supplemental EIS if it makes substantial changes to the proposed actions that are relevant to environmental concerns, or there are significant new circumstances or information relevant to environmental concerns and bearing on the proposed action or its impacts. The supplementation claims are really common in NEPA cases, and a body of law has developed around supplementation that doesn't quite match up with that definition. Generally speaking, that body of law recognizes that NEPA supplementation and NEPA review is not a Sisyphean task, that there's an end to it, and those ends depend on whether major federal action remains to occur and on the significance of the new information and whether it really changes the picture. So two things that CEQ could do is to clarify whether supplementation is only required when there remains major federal action to occur. That issue was actually just addressed a couple weeks ago by the DC Circuit again, and could really use some clarity from the agency in the regulations. And additionally, whether supplementation is only required when a seriously different picture of the environmental landscape emerges. That's a quote from DC Circuit precedent that is how the DC Circuit approaches the kind of second prong of NEPA supplementation, or the first prong, that being the significance of the new information, the second being whether major federal action remains to occur. So with that, I'll turn it back over to Fred.
Thank you, Tyler. For the lawyers on the phone, if some of you are lawyers and even some non-lawyers, just a bit of breaking news that might have you've seen on your phones. Justice Kennedy announced his retirement, which is not completely unexpected. But for those of you thinking about the world and jurisprudence and law, like we talked about earlier, that's yet another important development in the United States of America. So moving on, another issue deals with two of the most troublesome definitions in the entire lexicon of NEPA, and certainly in the NEPA regulations. And that is the three categories of effects that are defined in the regs: direct effects, indirect effects, and cumulative effects. The definitions themselves are fairly clear. A direct effect, the things that are immediately going to happen as a result of the federal action. But the amount of time and energy and ink that's been spilled dealing with the notions of the distinctions between direct effects, indirect effects, and cumulative effects is absolutely one of the oft-litigated and most troublesome concepts in all of NEPA practice. You see the definitions here on the screen. Indirect effects has a causation element to it. It's caused by the federal action, but still, and here's a key term, reasonably foreseeable. A cumulative impact, by contrast, is the incremental impact of the project, of the action, when considered in the context of past, present, and here's the term again, reasonably foreseeable future actions. Especially with respect to cumulative effects, agencies have struggled with this forever. They oftentimes forget the notion of incremental impact of the action and start doing an assessment of many, many other projects, not the one that is on the table or being considered pursuant to the notice of intent for the federal action. Similarly, for indirect effects, a great deal of time is spent trying to figure out, well, is this subsequent action really caused by the action that's on the table, the action that's being assessed, or not? We see this play out most often with respect to transportation projects. Induced growth, sprawl, is often thought of as an indirect effect of a transportation project, but the definition and scope of those indirect effects is completely controversial, and there's very little in the way of agreement about how to precisely define and to assess the scope of indirect effects. As a result, many cases deal with these issues, both in terms of the adequacy of the analysis, as well as has the agency made the right calls in categorizing the nature of the effects. Which raises one of the fundamental questions for the regulations: are these distinctions truly necessary? We've seen EISs, we've seen EAs, as you probably have, where there's a direct effect section, an indirect effect section, and a cumulative effect section on the same resource. You're trying to figure out air impacts, and it's broken down into these three separate categories, because after all, that's what the regulations say. You have to deal with these three different sorts of effects. It has the tendency to not only just increase the pages, but also increase confusion, to try to figure out really, if you're a member of the public, trying to understand more basically what may happen to this particular natural resource. Do those distinctions matter? Or do I really just kind of want to figure out what's going to happen? The agency just has to know what's happening as a result of the project and what's going to happen in the context of where this project is being located. That's what the bottom line is, and the question is, do these definitions truly help the process, or are they necessary to continue to produce NEPA documents at all? And the key practice pointers here relate to some of the terms that are always litigated. The reasonably foreseeable is the number one issue. Again, in the context of cumulative effects, you're trying to figure out if something else in the area is going to happen. So you're worried about a development that's going to fill wetlands. There's 3 or 4 other proposals that are out there that either have been in the press, they may be dealing with some zoning issues out there, and the question is, are they really going to happen? Are they reasonably foreseeable? So the incremental effect of your project, which may be X acres of wetlands, do we have to figure that out in the context of 3, 4, 5, or 10 different projects in the vicinity of where the project is being located? Similarly, for these effects determinations, agencies struggle all the time of whether a quantitative or qualitative assessment is necessary, and perhaps additional guidance in this regard is necessary. Do we apply models to figure out future induced growth, land use effects? Are those models very accurate? Or do we do more of a qualitative assessment, where in plain English we talk about the type of development that's being proposed, the type of development that's occurred over the last 10 years, or the type of development that's anticipated over the next 10 based on data that's in the public domain? And then similarly, when you're trying to figure out effects, how do we define the baseline? How do we define the no action alternative from which the effects analysis is created? So for example, there's many cases that talk about the no-build alternative, trying to determine, does that mean, is it static, as if nothing's happened? Or if we just don't build the project, what other sorts of things may reasonably happen? That creates a very different sort of baseline. And there's been plenty of cases that deal with that fundamental issue. And of course, depending on how the agency defines its baseline, will impact how it defines its effects analysis, whether those effects are direct, indirect, or cumulative. So is there a way to simplify this scenario, a way to simplify these definitions in order to make the assessment of impacts in EAs and EISs more simple for the agency? And I'm trying to advance Tyler or Jay. So can you do that for me? My clicker doesn't seem to be working. Can you go to the next one? Thanks. And then just the final is just a general consideration. There's a whole bunch of other terms. I've picked out two that I think are really important. The second one I'll talk about on the slide here first. We know that in MAP 21, for transportation projects only, Congress said that the final EIS and a record of decision shall be combined. On its face, it shaves off at least 30 days because the regulations have a 30-day cooling off period between a final EIS and a ROD. But in reality, we know it shaves a lot more because the way agencies have functioned, there's a lot more time between the FEIS and a ROD more than 30 days. And there were some objections to this statutory provision, but since it's been in effect now for 5+ years, 6 years, there really hasn't been much in the way of major controversy. The agency gives a heads up to the public that the FEIS and the ROD is going to be combined, so they have a notice of it, and off it goes. The question is, should that be institutionalized across the entire federal government? Has it worked? Is it effective? Is it another way of making the process a little bit more efficient? And then the other term is a little bit more complex, which is the notion of incomplete or unavailable information. There are many instances where the type of questions raised by stakeholders are very complicated, sometimes involve highly technical issues. And the questions the agencies grapple with continually is, how far do we have to go? If there is a model or a way to look at something, do we have to apply it? What if that model or the application of that model takes a lot of time and energy? It's very expensive. There's only one expert out there, or only a handful of experts who deal with this thing. And it's going to take 5-6 months, and it's going to cost $1 million more to do this kind of analysis. How is that necessary? And so the regulation says, well, there's a way that you can avoid that. You have to simply explain it in the record about why you're not doing that analysis and so forth. But there have been many instances in EISs that I've been involved in where that fundamental question about, is it too expensive, is it too complicated, is in and of itself a source of controversy and disputes between stakeholders, the agency, and project proponents. This could be a very helpful regulation to clarify so that the expectations of stakeholders are clarified somewhat, and they understand when this could be applied or when it's not. I would argue that many of the instances where you have very lengthy EISs, it's because simply the type of analysis that's at issue just takes time. It's complicated, it's expensive, and to do it right takes a lot of time. In some instances, you got to do it because it's the key resource impact. We've got to get some ideas into the decision makers' hands. We've got to give the public some idea of what's happening. But in other instances, it's just too complicated, and the output from that work isn't very helpful. So can CEQ provide us a little more guidance on how to apply that regulation, which has really been the source of a lot of confusion over the years? With that, we've concluded the topics that we picked out just for purposes of discussion with this webinar. Again, there are many, many others. And so I know that in advance of the webinar, when we sent out the final reminder, a couple of attendees sent out questions already. And I know, Jay, there was one in particular related to one of your topics that you wanted to address. So if you could kick that off, and then hopefully we'll see other ideas in the chat room that we could address for the remainder of the webinar. Jay?
Sure, absolutely. Thanks again, Fred. So the question that we received before this even started is this: can CEQ establish legally binding page and time limits that are relevant in a NEPA court challenge? For example, would it be a federal lead agency defense against an accusation of insufficiency to cite page or time limits? So there actually are multiple questions wrapped up in this. The first point is that it's not 100% clear that CEQ regulations are legally binding on other agencies. The D.C. Circuit has said maybe they're not. Other circuits have said, yeah, they are. There may even be a circuit split on that simple question. But I think the weight of authority is, yeah, okay, the CEQ regulations are legally binding. So what if they passed a regulation that said 2 years for an EIS, and then an agency said, well, in court, we would have done a better job, but we hit that time limit. Sorry. I I have a hard time picturing how that is going to be a valid defense against an allegation that the agency failed to take a hard look as the NEPA precedent requires. It's possible, I think, that if that were the only thing that happened and there were time limits and agency, met the time limits but maybe could have done more, quote unquote, probably courts would consider the time limits as part of their weighing of, is this a hard look or not? But I certainly don't think it would be an absolute defense. We hit the time limit, we were done. And I think maybe even a bigger problem really is before you even get to court, if you're a project proponent who's trying to get an EIS completed and an agency, as I suggested earlier, comes to you at, we're a month from the time limit, but gosh, we really need another year. What's the remedy for an applicant in that situation if the agency just decides we can't meet the time limit? Do you go to CEQ? What can CEQ do about it? Do you sue the agency that's trying to give you a permit? That's, something that we don't typically see. So I think it's a really good question because it hits on, exactly the reasons that time limits are sort of a surface level, a great solution. EISs take 4.5 years. Let's just make a rule that they can't take that long. But the real problem is something deeper and more fundamental to what's happening in the NEPA process. And just imposing time limits on it, I'm afraid, isn't going to be good enough either, in the practical NEPA preparation process or in court challenges to NEPA documents. I think we do have at least a couple of other questions, so Tyler's going to handle the next one.
We received a question following up on the greenhouse gas issue. CEQ withdrew its final guidance on consideration of greenhouse gas emissions and the effects of climate change in NEPA reviews. CEQ withdrew the guidance based on Trump's executive order on prompting energy independence and economic growth in April 2017. Might CEQ include a rule that climate change need not be evaluated? So CEQ certainly could reach this issue, I think most likely in defining a related broader NEPA terms, in particular the issue of reasonable foreseeability, which defines the obligation to consider impacts, indirect impacts, direct impacts. And so depending on what CEQ says in redefining or issues such as reasonable foreseeability, the new definition could at least limit an agency's obligation to consider greenhouse gas emissions. I think it's unlikely that CEQ would specifically target climate change impacts as something that need not be evaluated independently of CEQ defining an ambiguous NEPA term or redefining an existing term in the regulations that's unclear. But it could address the issue of reasonable foreseeability. This relates to some recent case law, including out of the D.C. Circuit and natural gas pipelines, where the D.C. Circuit held that FERC was obligated to consider the downstream greenhouse gas emissions that it believed to be reasonably foreseeable in connection with FERC's decision to license natural gas pipelines in the Southeast. There's a split panel in the D.C. Circuit, but CEQ might take on the crux of the issue there, which relates to a previous Supreme Court case called Public Citizen, and is when an agency is not a legal cause of downstream effects of the impacts of its project. And so one way CEQ can limit the obligation to consider climate change might be to flesh that out. What is the legal cause analysis that's discussed in Public Citizen and other case law really mean? We received another question that I'll turn to now, and that is, what thresholds are likely to result in more environmental impact statements being prepared? Right now under NEPA, it's the significance of the project as a whole that matters. Adding thresholds could make NEPA more like CEQA, the California Environmental Quality Act, where a single impact can require the preparation of an EIR rather than a lower-level document, environmental impact report. So CEQA is similar to NEPA, but has some major differences, including that any significant impacts need to be mitigated to below a threshold of significance if feasible, and more or less. And so it's a good point. So in determining whether an environmental impact statement is required, it doesn't depend on a particular impact or one specific intensity factor. It depends on the project as a whole. And to answer the question here, I don't know if providing clarity on when a particular impact is below a significance threshold would convert this into a more of a CEQA process where one significant impact could push the project towards an EIR and eventually result in mitigation. I think part of the difference is that NEPA doesn't require mitigation, but I think that right now that's already how it works. If you have a significant impact under NEPA that can't be mitigated to below a significance threshold, then you need to prepare an EIS. So I think focusing on the individual intensity factors and particular impact is already required under NEPA, really, and further clarity could be helpful in reducing litigation risk attendant to agencies' conclusions that an impact like certain air emissions are not significant on nearby surrounding communities. I don't think that every single impact will be amenable to defining such a significance threshold, however.
The next question we've received is this. If CEQ changes their regulations, how does it get the federal agencies that administer NEPA to implement those regulations without each agency having to do its own rulemaking, which obviously could take a long time? It's an excellent question. Again, it kind of goes to what we were talking about earlier about the CEQ having limited influence really over how each agency handles its NEPA process. I guess my thought on this is as long as CEQ is amending its regulations, probably one thing it really ought to consider doing is creating some sort of regulation that would give CEQ some additional authority to influence the way the agencies are handling NEPA. It's always struck me as odd that every agency has such very different ways of complying with NEPA. Not just different rules, but even as a matter of practice. We're in front of agencies of all different sorts and all different places in the country. Every single Corps of Engineers district in the country has sort of a different way of doing NEPA. If CEQ could amend the rules to force some additional uniformity, and those rules are binding on the agencies, and CEQ puts in a rule that allows it to have some influence over those agencies, some direct influence, not just a reference up to CEQ. It sounds like an expansion of the CEQ bureaucracy, and it probably would be, but as we sit here right now, don't see much other way for CEQ to tell the other agencies what to do. Fred, do you want to weigh in on that at all?
I do. One of the big things that we struggled with at DOT was the fact that the modal administrations all had their own NEPA regulations, and we were all under one roof. And in many instances, we were doing multimodal projects, so 2 or 3 of the administrations were working together, in theory, and we had to figure out whose rules applied. That didn't seem to make any sense whatsoever. So it seems to me that, when courts look to the regulations, they most often look first to the CEQ regulations as opposed to the individual agency rules. And one way that the CEQ can try to deal with this in the regulations is a request to harmonize to the maximum extent practicable individual agency practices with these regulations, with provisions to allow for variations based on the specific agency mission. In other words, to try to limit those instances where there's variations on the theme. We tried to do that, the US DOT. We created a one DOT NEPA order, it was called. But even that took many years to put together because agencies were reluctant to give up their own processes in the context of their own programs. But I think it seems it's incumbent upon the CEQ to put a greater emphasis on its rules and then harmonization of its rules across the federal government.
Okay, let's see. We have a few more minutes that we're still getting more questions, and we may not get to all of the questions. And if we don't get to your question, then please don't hesitate to send us an email. We're more than happy to continue talking about these issues as we go. The next question that we're going to try to answer here is, can the definition of what constitutes a major federal action be constrained to the decision space of the decision maker? Can the resources discussed in a NEPA document be confined or at least focus on the scope of the decision maker's authority? I think that question kind of goes to the idea that agencies under the current rules are required to consider alternatives that may be outside of their decision-making authority. And that does come up a fair bit. I certainly think that is something that CEQ will look hard at as it revises the rules. I guess as a practical matter, it strikes me that there are definitely instances where agencies go way too far in looking at things that they have almost no control over, and somehow when they do that, they end up just making things up, which doesn't make much sense to me. There are other situations where it may be obvious what an alternative would be that's outside of the agency's authority. So, I think this is definitely something that's ripe for clarification and potentially narrowing. Tyler, do you have anything you want to add to that?
Sure. Yeah, there's NEPA case law that holds that agencies even need to consider alternatives in some cases, at least to some degree, that would require a statutory amendment. And so the existing case law is pretty expansive. The one question is whether those decisions flow from an interpretation of NEPA, the statute itself, and whether the court in those cases found that expansive view of the alternatives that need to be considered was required by Congress, or whether the interpretation stemmed from an ambiguous part of NEPA that an agency can define and redefine. And it's a closer question when it comes to something like whether alternatives outside that would require a statutory amendment need to be considered, because there is language in NEPA that requires NEPA review in connection with proposed legislation. But particularly an issue like whether an agency needs to consider alternatives that's outside of its jurisdiction and in another's is something that does seem like it's right for CEQ to weigh in on.
Yeah. I'll just throw in that vein that there's a 1979 Supreme Court decision called Andrews against Sierra Club, where the court says something along the lines of, the Supreme Court will defer to CEQ's interpretation of NEPA, but since that decision, there's been all kinds of case law development on exactly when courts should defer to agencies. There's Brand X. I wouldn't spend too much time thinking that 1979 Supreme Court decision would be an obstacle to a court adhering to its old position that, oh, well, you have to consider things outside your jurisdiction. So it's something that they could definitely go into the rules, and how it played out in the courts, I think, is a big question mark. We're coming right up on the end of the time here. There's one more question we'll try to get to. What is a reasonable expected timetable for CEQ to issue its notice of proposed rulemaking and final revisions to the CEQ regulations? Given that they're obviously pushing this forward quickly and they got such a short turnaround on this initial notice, my rough guess would be you could probably see a notice of proposed rulemaking sometime this fall. They'll take comments, they'll respond to those, they'll come out with something in the fall, and they will inevitably get an amazing number of comments on whatever notice of proposed rulemaking they put out. But I still would think if this is truly a priority, which it seems to be, maybe by the spring or summer of 2019 there might be a final rule. Okay, well, it's 3 o'clock, and we really, again, appreciate everyone joining us. I'll say again, you'll get a copy of the slides that will have our contact information, and if anyone on the phone has a question that didn't get answered or a different question that comes up, please do not hesitate to give us a call. With that, we'll end the WebEx and say thank you very much.
Thank you very much.